Thank you very much, Professor Reddock. I think she raised some questions that we want to continue to consider, which is how can we engage in the current public discourse on this issue of the Marriage Acts while taking into account cultural, ethnic, and religious claims on the bodies of girls and women in particular, while also keeping in mind the question of girls' human rights. As we move into the other presentation, something to also consider is when we are thinking about the question of standardizing or harmonizing the acts, what is the basis for the ages that we consider to be appropriate for girls and women, and how does that speak to the other pieces of legislation in existence? And finally, what is the continuing role of the women's movement in terms of putting on the table the issues that we want to be considered? So coming from her presentation, we're now going to hear Ms. Gaietry Pargass on a legal perspective on these acts. Gaietry?
Thanks, Gabby. Well, quite clearly there's overlap between Professor Reddock's presentation and mine. She went into some detail on the acts. But having said that, I still want to make a few points. The contradictions in the law, the contradictions between the law and the conventions that we have acceded to, and the capacity of the government. I want to argue that the government in and of itself can advance this discourse without necessarily, while important, being hampered, as it were, by the intersection of the religious and cultural discourses with the age of marriage. So I just want to start by looking at the first act, the Marriage Act, and just to say historically, we inherited that act from England. That act in England dated back to several centuries, 15th, 16th century. And the actual ages of marriage in that act, they are not spelt out as she clearly said. There's an age of consent, which is 18, but the actual age for marriage, unlike the other acts, that is not spelled out. And I will make the link. Under the English common law, what we call the common law, the system of law that existed in England, which was the law that grows out of judgments, courts, and so on. That is how the law operated several centuries ago in England between the king and the courts and so on, and where law came from. Those common law ages in England were determined to be 12 for girls and 14 for boys. 12 and 14. And interestingly, this was patterned on canon law, canon or church law. This is how this originated. The canon law was that the ages at which boys and girls were deemed to have capacity to get married were 12 and 14. And that is how 12 and 14 came to be the common law, which we inherited. And if you look at the time the act was promulgated, which was 1923, here in Trinidad, the Marriage Act, we would have obviously inherited those common law ages. Now, you don't see those common law ages expressly provided in the Act, so they are not really in the public domain. They don't become part of the discourse, when in fact they offend the principles that we are talking about much more than the Hindu Marriage Act and the Muslim Marriage and Divorce Act. The common law position under the Marriage Act, which applies to Christians and all civil marriages, and all civil marriages apply to everyone, irrespective of religion. As long as we choose to get married under the civil law provided by that Marriage Act, if we go to the magistrates' courts, for example, where the district registrar, the magistrate usually acts as a district registrar, sorry, that those ages of 12 and 14 apply to all of us. Therefore, we have that position which applies universally in Trinidad and which also applies to Christians. But the governments, successive governments, because there have been efforts, I was involved in efforts in the early 90s with respect to this issue, and Rhoda mentioned later efforts in 99, and there may have been efforts before, I'm not quite sure. And what has always been recommended to successive governments, and even as recently as a piece I did not long ago for the then Center for Gender and Development Studies, is that the government can lead by example and change the common law ages. The government can abolish the common law ages which apply under the Marriage Act and ensure that there is an age under the common law, under the Marriage Act, which applies to all Christians, but to everyone else under civil marriages. I have not been able to understand why there has never been that political will to make an essentially very powerful statement. Because if the state were to change those ages, 12 to 14, and let's say with some kind of discussion with the community, because it's not easy to reach a consensus on marriageable age in many communities, but let's assume a consensus is reached that it should be 16. There is no reason why the government cannot move and do that. Pass the legislation, introduce the bill in the parliament, and sever the civil position from the religious position. I want to argue that the state perhaps conveniently hides behind the religious and cultural discourse without taking responsibility for leading by example and by making what is in effect a very powerful statement to say we will change the law when it comes to civil marriages. The other point I want to make about that Marriage Act is that it is clearly in conflict. The Marriage Act, the 1923 Marriage Act, which has been amended from time to time, it is clearly in conflict with two UN conventions that we have ratified. The government ratified the Convention on Consent to Marriage, Minimum Age for Marriage, and Registration of Marriage on 2nd of October 1969. And that convention requires that parties that have ratified that convention must expressly provide in legislation minimum ages for marriage. Because the Marriage Act does not expressly do that, it infringes that convention. Similarly, Article 16 of the Convention on the Elimination of All Forms of Discrimination Against Women, the Trinidad and Tobago ratified that convention in, I think, February 1990. And again, that requires that states must put in legislation what is the minimum age for marriage. And while obviously based on what Rhoda has presented and what the other presenters will be saying, there are cultural and religious issues which seem to be inextricably interwoven into the other acts. The state is, in the act that it has, quote unquote, control over, it is infringing the very conventions that it ratified and committed to expressly state its age of marriage in the legislation. The Marriage Act itself, in line with the Orisha Marriage Act, has a much broader, a much more liberal provisions for consent. And consent is at section 23. The consent is of both parents, if they're alive and living together, a parent with whom the minor is living, etc. So it's not, in this case, the father that has precedence. It's only in the Muslim Marriage and Divorce Act and the Hindu Marriage Act. The third point I wanted to make was that there is an issue of a contradiction between the ages for marriage in many cases, not in all, because in some of the cases, as Rhoda pointed out, it's 16 and 18. But any age under 16 is in conflict with the age of consent to sexual activity. So in Trinidad and Tobago, under our Sexual Offences Act, the age of consent to sexual intercourse and to other forms of sexual activity which are allowed in the law, that is age 16. But because we have positions where girls can get married as young as 12 and 14, and boys in some cases at 16, well, it would be under 16, there's clearly an inherent conflict between those two. And to me, the positions advanced by the representatives of the Hindus and Muslims, they do not, and they are not able to reconcile that difference. They are not able to. In one case, it is a hefty criminal offense, and in another case, it is okay once you are married. And that's a contradiction. What I should add is that girls, though not boys, and we don't know why not boys, but I mean, that also has its historical basis. Under the Sexual Offences Act, girls under 14 cannot have sexual intercourse. Girls under 16 also, but there are defenses for girls between 14 and 16. But under 14, there is no defense. So even if the girl says yes, the penalty for that is still life. So the contradiction is huge, because on the one hand, you're saying girls under 14, once a male has sexual intercourse with that child under 14, then irrespective of whether she consented or not, she cannot consent in law, the maximum penalty is life. But once she gets married, then, it's okay. And that's an issue which has to be debated in the discourse that's opening up. How do we reconcile those two? There are other things I want to say, but they can come up in the questions. But there is another contradiction in the Acts and a child's capacity to consent to marriage. Both the Hindu Marriage Act and the Muslim Marriage Act has a clause, a section, that says that there are a list of prerequisites, what the acts determine when is a person ready to get married, and they have to conform with that list of things. It's also in the Orisha Act. Both parties shall, as regards age, mental capacity, and otherwise, be capable of contracting a valid marriage. And there's a huge contradiction there. I don't think the Marriage Act has that precondition. But the precondition in the other three acts is that both parties shall, as regards age, mental capacity, and otherwise, be capable of contracting a valid marriage. And one would ask, how can a child of 12 or 14 be capable of contracting a valid marriage? The age of majority here is 18, and one cannot enter into any contract except what is called contract for necessaries under 18. the law does not allow a person under 18 to enter into a contract. Yet in an enterprise as big as marriage, the assumption is that a child of 12 or a child of 14 has that capacity to enter into the marriage contract with the consent of, the list of people that Rhoda mentioned. Finally, I want to conclude that one of the ways forward is that first issue I touched on and which I have recommended twice already in studies that I have done and included this issue, that the government can move ahead and amend the Marriage Act, change the age of marriage, unify the age of marriage under the Marriage Act to an age that is obviously acceptable, and I often have used 16 as the cutoff point. It can be higher than that, but most countries, or a lot of countries around the world, 16 is the sort of average. You'd be surprised that many states, especially the southern states in the US, they still have 14 is still the minimum age for marriage. And so I would say that when as the debate continues, we should call upon the government to lead by example and to change the minimum age for marriage under the Marriage Act, the common law ages of 12 for girls and 14 for boys. Thank you.